Welcome to Deals and Disputes with the West Webb Law Group.
Welcome to today's episode of Deals and Disputes with West Webb Allbritton Gentry, where we explore some of the most pressing legal challenges of our time. I am Kevin Rosenquist, and I'm here with Jay Rudinger, partner, West Webb Allbritton Gentry. Today, we're going to dive into defamation defense and free speech in Texas, a very important topic. Jay, welcome to the show.
Happy to be here.
So to set the stage, what exactly is the Texas Citizens Participation Act? And why was it created in the first place?
Sure. So we call it TCPA for short. So the TCPA was created in 2011, and Texas is one of, I believe, almost 35 states now that have enacted similar. Obviously, they're not word for word, but they're very similar concepts of statutes and laws, and they are designed to be anti-SLAPP laws. So a SLAPP is a strategic lawsuit against public participation. So acronym is SLAPP for that. And these were designed to help people that are kind of talking about a matter that everybody might want to hear about, a topic that's in the public or something that relates to the public safety or something along those lines. And they come out and they want to talk about it, a whistleblower or just public discussion, that suddenly somebody else gets upset about what they said about them or what they said about their project or their company, and they can bring a lawsuit against you. And generally when you get into a lawsuit, you're into a protracted fight that's going to go on for months or years or 5-6 years, depending on how far the appeals process can go. So what the TCPA was designed to do is to kind of call timeout right at the front end and say, if this is going to be based on your participation in the public and either right of association, right of free speech, or right to petition, we're going to let you have an opportunity to go ahead and kind of stop us where we're at right now. So a lot of the states had seen the laws and the lawsuits and everything started to boil over. And generally it was a big name that was claiming defamation against somebody that was small, a reporter or, a small fish in the pond. And when it came to resources and financial resources to fight it, there were just folks that they didn't have that for a long protracted fight. So the anti-SLAPP and the TCPA in Texas specifically is kind of designed to help cut to the chase, go ahead and see if this is a meritorious claim or if this is something we can go ahead and get out pretty quickly.
Who tends to use it in real world disputes?
It's kind of interesting. It was started in 2011 and kind of lay dormant for quite a few years. It was out there for free speech and a few other constitutional rights association petitioning. People really kind of stuck to those areas of impact for the TCPA. And then there was a few cases and a few line of cases that kind of turned it from a scalpel into a sledgehammer, and it broadened what could be covered by the TCPA and in ways that it could be applied to outside your traditional defamation. I say something bad about you and you go to court and say you've defamed me and cost me money. And it bled over into business disputes. It bled over into employment areas that people had no idea we were going to get into. One of my favorite was a Little League umpire that had been sued someone for what they yelled at him on a baseball field, and they used the TCPA to get the lawsuit dismissed. And in instances where you wouldn't think those things would come up, or areas, an employee that got a bad review from a former employer says, "Hey, you hurt me. I didn't get my job at this next spot." And they're like, "Well, that's free speech on our part. We're going to use the TCPA and get this out of here pretty quick." And it kind of slammed the doors open on what it could be used for. So where I think probably when it was enacted, everybody thought of your traditional constitutional remedies and the First Amendment. You have the right to associate, you have the right to free speech, and you have the right to petition. And the courts kind of said, we're not limited by what those constitutional protections are. We're limited by what the law says, or the Texas law says. And it's a little bit broader than that. The term of art they used that it was applicable to was a matter of public concern. And it's a defined term. And it turned out you could kind of drive a dump truck through what those words were. It was pretty amorphous. It was as far as you could kind of stretch your imagination to what the public would be concerned about, or what was public safety, or what people would want to hear about. And for instance, you wouldn't think a Little League game is going to be a matter of public concern.
No.
But it was that the court looked at it and said, well, there's a bunch of people out there. They want to have fairness and equity on their Little League baseball fields. that's a matter of public concern. So we're going to go ahead and apply it here. So they kind of made it to where it was much more of a sword in a lot of instances than it was technically even a shield in some of those cases early on.
You had mentioned that it can show up in business as well. Are there certain types of cases, whether it be business or a public figure or an umpire, or just something as simple as an umpire, where the law shows up the most?
I would say what you'll see a lot of is mostly, I would say in the business context, there's a few areas. One that it had been for quite some time was trade secrets or misappropriation of trade secrets or business disputes. And when you terminate one employee and they go to a different company and they'd start working with that other company and they'd use some trade secrets that they'd gotten from you or know the contact list or the client list. And there were some lawsuits and they said, you can't do that. We're being injured by that. And under the rule of right of association, which didn't have a matter of public concern component to it, they said, well, I, as a new employee, want to associate with my new employer. We have the right to associate under the TCPA. We're going to go ahead and get this thing dismissed. I can use your trade secrets. Sorry about it. And that has subsequently been fixed in amendments because that was kind of a novel idea, and everybody realized, whoa, we might have put a cart before a horse here.
Yeah, no kidding. So it worked in that case.
Other things. Yeah, so it had been used in those instances to where the legislature came back and has extended. They started off with a much shorter exemption list, and they have added to it 4 or 5 times through different bills and different laws to try to create, hey, you can't use it in this setting. You can't use it in that setting. We're not going to let you try to get out of a personal injury lawsuit because you said something to the police, and that's your right of free speech to talk to them about how the light was red or wasn't red. So they have found ways to carve out that. But then the other setting you see is kind of in an employment context where an employee is terminated and they go to Facebook and want to say my boss did X, Y, and Z, and it's a terrible place to go work and you're never going to want to go work there. Well, if it is a matter of public concern, if you're saying they are not safe, instances that you can think of, like if it's a daycare or if you're at a school or if you're at something that really could affect the safety of people, and the court can look at it and say, that is, the public should be able to hear what you have to say about this, right or wrong. Again, we're not looking at necessarily the applicability. The TCPA is applicable of right or wrong, whatever you want to say. We're just going to say it's, we can apply that law to it. Now there are some other hurdles to clear as you go through it and in the process of how it plays out in the courtroom, but we're going to go ahead and let you apply it. So it can be the employee saying something, or in that case, I mentioned the employer saying something of, hey, this employee was sleeping on the job. If you're hiring him to go out there and drive a bulldozer all day, you don't want him sleeping on the bulldozer and running somebody over. So I'm going to tell you that that's his problem. And it's a matter of public concern because whoever you're going to run over probably really cares about that fact.
Yeah, I would guess so. Yeah. Interesting though, how there were so many different things that they did not see in the law initially that where it could be used. That seems like it's a common occurrence.
It is. Unfortunately, we write the laws and our lawmakers do as best they can. They get input from lawyers all over the place to try to tighten them down and look at them. And our job is to try to find the loophole and say this could be a problem, but you can never truly be as clear as you would like. And then it's up to the courts to apply the law and kind of interpret what it was. And in this instance, I think the Texas Supreme Court, when they kind of moved the needle a little bit, and it was the employee that had gotten the bad review, was with ExxonMobil was who the party was. They kind of threw the door open on where this can be applied precedentially because of their ruling. And it took the legislature a session or two to kind of catch up and realize what was going on. It was used in a attorney discipline case where somebody had filed a grievance against an attorney. And it was actually our firm was part of that representation, and we asked the TCPA to be applied, and one in the trial court. It was flipped over on appeal, but we were able to get it applied to there. And in the next session, an amendment came out that says it's no longer applicable in attorney discipline cases. So they've kind of played whack-a-mole a little bit as stuff has come up, and they've looked at it and said, well, that's not what we intended, so let's go ahead and take that out. Like the trade secrets one's a good example of, well, we never intended us to, companies to lose their rights to protect their trade secrets. So let's figure out a way we can make it so. And again, the TCPA, just because it's applicable, doesn't mean it dismisses your lawsuit. There's ways that it operates through the courtroom and through the process of the motion to dismiss that lets you overcome it, but just the applicability of it 60 days in, and really one of the big tools and weapons that the TCPA gives is something called an interlocutory appeal, which regardless of how the court rules, if they deny the motion to dismiss and say this isn't a matter of a free speech or an anti-SLAPP lawsuit, you can take that up immediately on appeal and it pauses the lawsuit. And the appellate process from the trial court to the Court of Appeals to the Texas Supreme Court can be a 2.5 or 3 year process. So you file your lawsuit to try to get damages or remedies for whatever somebody said or did or whatever capacity it is, and somebody asserts the TCPA before you even have an opportunity to ask them a question almost about what they said or get to the merits of it. You could be 3 years down the road and tired of this whole process and spend a whole lot of money trying to fight through it. So where it gives you the opportunity to quickly dismiss a lawsuit, it also gives you opportunity to quickly, even if you lose, tie it up in the appellate courts and as it moves forward.
Have you seen situations, maybe some unexpected places where the law shows up where it doesn't end up as an amendment later, where it actually is like, oh, that actually fits?
They have done a really good job kind of curtailing the fringe use of it. They've really gotten back to kind of the constitutional roots of it. It's not limited by our Constitution or the First Amendment or the 14th applied to states, but they have kind of honed in on what that freedom of speech, freedom of petition, and freedom of association is, and where matters of public concern were previously a little more amorphous in what that meant, they've now defined it to a public figure, public safety, a moral or ethical issue, something or something that the community would want to hear about. So again, kind of amorphous. You can argue there's a whole lot of things that the community want to hear about, or what is public safety, or what are those different areas. But I think you tend to see it in some novel areas, and the courts have kind of followed the legislature a little bit after the amendments were done in 2019 of, look, we understand that it might be, you could make that argument and you could say that this is the TCPA that covers this, but we're not going to let you kind of get away with some monkey business here and trying to shoehorn a square peg into a round hole.
Other than the amendments, has there been any other like changes or shifts in how the law is used?
Really, the amendments have gone a long way in kind of curtailing it down. You try to find, every time it comes in, every case we get in, if we're on the defense side, we look at it and say, is this applicable? Because there's a timeline on when you can do it. You have 60 days from when you're served with the claim to be able to file a TCPA motion. So you're on a pretty tight timeline in evaluating what you've got. So they've done a pretty good job of narrowing it down to those issues that are probably more traditional. Some areas that you can still get a little bit creative with its use in, but a lot of those exemptions and exceptions that they've put into the law have done a lot of kind of tightening it up. And plus, post-amendment, some of those previous cases that would have been precedential and would have been controlling, once it's amended, you can kind of ignore those and say, well, that was on the old law. Now we have new law, so we can kind of clear the slate and start over a little bit. So what was a pre-2019 case doesn't necessarily bind us in a post-2019 TCPA to be able to say that, yeah, because they said that guy, the employee, was clear, then the Little League umpire was there. Well, that was pre-amendment. Now we're going to get back to something that's a little bit more relevant to the anti-SLAPP issue.
And when someone comes to you with a case, what kind of questions do you ask, or what kind of things do you look for to see if the TCPA can be applied?
There's a pretty robust definition section in it's Chapter 27 of the Texas Civil Practices and Remedies Codes, where the TCPA is housed. There's a pretty robust definition section that says this is what you get for your right of petition. These are the things we have to have for right of association, and then the free speech with what's the matters of concern. So one of the things I want to do with a client when they come in is talk to them and ask them, hey, here's where we sit, here's where we stand. Let's kind of go through this checklist over here and say, is it okay? You weren't filing a lawsuit, you weren't in a government proceeding, you weren't in any of this, so we'll just go ahead and move on down to this. Is there a free speech? Is it a public person, not a public person? So we kind of just run through that checklist and see. Because it's worth taking that step, because if you're a defendant, In most instances, the defendant isn't ready to, doesn't want to race down to the courthouse and try a case and go prove their right. That can be in some instances, that's exactly what you want to do. In some instances, we're still trying to figure things out, or, hey, look, we have a way to make this thing stretch out 3 more years and see if they really are that interested in trying to take that next step. If they really want to fight about it. Generally, you've had discussions and negotiations. The reason a lawsuit's filed is we've reached the end of whatever we could or couldn't do, so we're going to have to figure it out. So the TCPA just kind of gives you that option to go in. Again, like I said, the plaintiff has an opportunity once you show that it is the right of free speech, right of association, or right of petition in the lawsuit. They have a way, and I believe the definition in there is clear and specific, which is a pretty clear and muddy, whatever that actually means. No one has said really, other than if you were to go to court, if you were in your court of law, you have to show preponderance or clear and convincing. So again, another instance of our legislature wanting to be as specific as they could and use new language that has not been in any other law, that everybody had to try to figure out what they meant. But they have an opportunity to show their case and show the elements of their case and say, yeah, the TCPA is applied, but here's where they said what they said, here's the damages that I have, and I should be able to go forward in court. And that can overcome the TCPA. Now, there's also affirmative defenses. So if the defense has, well, what I said was true, and that's an absolute defense to any defamation action. So if you, even if you say the TCPA shouldn't apply because they said these things and I was damaged, well, here's the proof that this was true. We still need to be thrown out of here. So there's, just because the TCPA is asserted or even triggered doesn't mean that the plaintiff's day is done. But what it does mean is if you're bringing a obviously a defamation lawsuit, but even more so one that might be even on the fringe. So you asked about talking to your clients when they come in. If we're going to file a lawsuit, I want to look at those issues and say, do we need to plead this so we can avoid the TCPA? Mm-hmm. We want to make sure that we're not giving them grounds to try to come back in and assert the TCPA. So we want to make sure that we don't accidentally use, we use language that could be construed to say this is a matter of public concern. We want to make sure we're concise, we're accurate, we're truthful, and that we're telling the pleadings right, but that we're also cognizant that we don't somehow, the way we use our words or terms of art, get ourselves into the TCPA realm.
Good point.
Because then you're into a 3-year wait. If it is a defamation case and you're like, okay, we're going to be in the TCPA, we're going to be fighting that. Before you file that lawsuit, you better have your evidence ready to go. You better have the proof ready to win a hearing at the front end that says, look, I can still go forward with my case because I can, while the TCPA is applicable, I can show you my elements of my causes of action by clear and specific evidence.
Wow. It's interesting stuff. Interesting how it's evolved over time too.
It is. And it's kind of, like I said, it's sat dormant for a while. And then a couple uses of it that became creative kind of blew the doors off of it. And you were finding it in all sorts of different areas, in all sorts of cases. Every case that came through the door, we were ethically obligated to see if the TCPA could apply, because if we're a defense, we can string this out and save money and push it down the road and see if they really want to do it. We're obligated to do that. That's how we fight for our clients and give them the best outcome possible. So it has been narrowed down pretty tremendously over the last 4 or 5 years. They still are narrowing it. I know they just added another one in 23. It became applicable that malpractice claims against lawyers you couldn't use the TCPA to try to get out of a malpractice claim. So they're continually touching those exemptions and making sure that, hey, look, we're not going to let you try to, what could be a true claim, try to sneak out of it on what isn't what you would consider traditional free speech, First Amendment issues. So we're not going to let you try to run for the fire exit on the side and delay this thing as long as you can.
Mm-hmm. Yeah. All right. Well, thank you for tuning in to Deals and Disputes with West Webb Allbritton Gentry. To connect with the team, visit westweblaw.com, and that is web with 2 B's. And don't forget to subscribe to our channel and leave us a review. We appreciate it. Jay, I really appreciate your time. Thanks so much for being here.
Thank you for helping with this.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.